Okay, in this video, we're going to be discussing or continuing to discuss the concept of fair use and how fair use determinations are made in relation to particular cases. In the last discussion, we looked at what I like to refer to as consumptive fair use, where the allegedly infringing work is a literal copy or a literal act of copying of the plaintiff's copyrighted work of authorship. And the question is about whether the way in which that literal copying is effected or the way in which the copies are used is transformative of the original purpose of how the works were intended to be used or intended to be marketed, such that the form of consumption, as it were, constitutes a fair use under the circumstances. In this video, I'm going to be talking about a different kind of transformation or a different kind of fair use involving derivative works rather than reproductions, right? So this is a circumstance in which the allegedly infringing work is not a literal copy of the entire original work of authorship owned by the plaintiff, but rather a derivative work that uses elements from the plaintiff's work of authorship and incorporates them into a new work of authorship, which may be, or which is, for the purpose of the infringement analysis, substantially similar to the plaintiff's work of authorship, or maybe not, right? And we'll get into that question in a moment. In other words, thinking about what we mean when we talk about fair use in this context, as opposed to when we talk about fair use in a literal copying consumptive context. So same statute, of course, and same four factors. And so then the question becomes, how should we think about different kinds of uses or different kinds of uses of, different parts of works of authorship in this kind of context? Specifically, how should we incorporate ideas like criticism and commentary into the fair use analysis in relation to using elements of a work in a new work, as opposed to using copies of a work in a way that's different from the way the copyright owner uses them, and potentially in a different market from the one in which the copyright owner is operating. So the kind of key example of transformative fair use is the Campbell v. Acuff-Rose case decided by the Supreme Court in 1994. And this involved a scenario where Roy Orbison, who had recorded the song, a very successful song that he'd written, "Oh Pretty Woman," in the 1960s, and been released in the 60s. It was a very well-known song, very popular and a significant revenue generator for the copyright owner, Acuff-Rose, his publisher, to whom Roy Orbison had transferred copyright ownership of the musical work in question. And what happened was Two Live Crew, a rap group from the late 80s, early 90s, wanted to do essentially a parody version of Roy Orbison, right? They were sort of framing themselves sort of as the hip hop Weird Al Yankovic group, kind of under those circumstances, and they wanted to take the Roy Orbison track "Oh Pretty Woman" and do a send up, essentially, of Roy Orbison, and what they saw as the sort of anachronistic and somewhat unimpressively cheesy sort of perspective of the Orbison song. So they approached Acuff-Rose actually and said, their record company approached Acuff-Rose and said, we'd like to license "Oh Pretty Woman" for the purpose of doing parody on our album, right? A reasonable enough approach, offering to pay for the right to use the work in question and create a derivative work from it. And Acuff-Rose said no. Right, we don't want to see a parody version of this song, and in particular, we don't want to see a parody version of the kind that you're proposing, right? Because despite the title of the album they're planning on releasing, As Clean as They Want to Be, Two Live Crew was in fact not a particularly clean group in the in the traditional sense of the word. And in fact, their songs were notable for being quite sexually suggestive. Although the original song "Oh Pretty Woman" was in fact a song sung from the perspective of a man looking at a prostitute walking down the street, hoping he could interact with said prostitute, it was perceived as being relatively chaste at the time, as opposed to the Tree Life Crew sort of image, which was perceived as being highly sexualized. In any case, Acuff-Rose refused to license the song to Tree Life Crew, and Tree Life Crew went ahead and recorded and released the song anyway, because they had planned to do so, and they didn't see any alternative option. At which point, Acuff-Rose brought an infringement action against Tree Life Crew, specifically Luther Campbell, the kind of impresario behind the group, and this was litigated all the way up to the Supreme Court, which was presented with a situation in which essentially the lower court had said that the Tree Life, this was a fair use defense on the part of Tree Life Crew, right? There's no question that they had copied elements of Roy Orbison's song such that it was possible to find that their song was substantially similar to the Roy Orbison song. And the question was whether or not they could assert a fair use defense under the circumstances. And the lower court had concluded that no, they could not, because they were releasing their song into a commercial marketplace. And as a commercial work, it failed to satisfy the first prong of the fair use test, which, as you'll note, says it encourages or instructs courts to consider whether the use is of a commercial nature or is for nonprofit educational purposes. So the court essentially said, look, you're releasing this commercially, that's a commercial use. You can't satisfy the first transformative use factor of the fair use test. And the Supreme Court ultimately disagreed, right? It said releasing something commercially does not bar the possibility of the work being transformative, right? So the fact that you're releasing it for money doesn't mean that it can't satisfy the transformative use test, although it's a consideration to take into account in determining whether or not a particular use is in fact transformative or not. But the reality is that, we live in a commercial capitalist society, and, in order to make it possible to create works of authorship in the first place, creators are obligated to derive commercial revenue from them, and therefore merely selling copies of the derivative work in which you're making a fair use claim is insufficient to make it a per se infringing non-fair use. So the court then reflected, as it were, on the factors that ought to be considered in the circumstances, and specifically focused, for better or for worse, on the fact that the Tree Life Crew song in question was executed in a literary or in a genre, the kind of cross-medium genre known as parody. Right. And so the court said, look, when you're thinking about whether or not an allegedly infringing work is transformative or not, you have to think about transformativeness in context, right? And so among other things, you have to consider the genre in which the work is being produced, right? Essentially, one has to ask whether or not the materials used are necessary in order for the allegedly infringing work to exist in the first place, in order to determine whether or not sufficient transformation has taken place. And so the nature of the use that can qualify as fair use is going to depend on the nature and the purpose of the use in question. And so here, when we think about this in the context of parody, the Supreme Court says, look, in order to make a parody, you're obligated to copy material from the work that you're parodying. If you didn't copy anything from the original work that you're parodying, it couldn't be a parody because no one would have any clue what it was you were poking fun at, right? The entire purpose of a parody is to make fun of a previously existing work. In order for the parody to function as a parody, one has to engage in copying, and in fact, one typically has to engage in a substantial amount of copying. And therefore, not only is copying in the context of parody potentially transformative because you are taking a work and transforming it into a parody of itself, but also a very substantial amount of copying might be justified in the context of parody. More copying might be justified in the context of parody than might be justified in any other than in other contexts, because in the context of parody, copying a significant amount from the original is necessary to the genre in question. Now, many courts, for better or for worse, really for worse, took from this Supreme Court decision a kind of heuristic that parody is fair use and non-parody is not fair use. And that's just not what the Supreme Court said. Can't even say it's really a wrong interpretation. It's literally not the position that the Supreme Court took, but it is a interpretation or reading of the Supreme Court decision that is quite common, probably a function of the Supreme Court's own less than stellar job, as it were, at explaining why it was talking about parody in the first place and why parody mattered in the context of the evaluation that it was actually doing. In any case, Supreme Court says, doesn't matter that it's commercial and doesn't matter that it copies a lot, because it's parody, copying can be perfectly fine. And the correct way to evaluate whether or not the parody in question is a fair use is to look at whether or not it is in fact transformative in relation to the two works in question. In other words, you got to compare the two works and determine whether or not it's transformative in context. Okay. The court then marches through the other two factors, asking, well, what about the nature of the work? Sure, these are not factual works. So, the second factor weighs in favor of Roy Orbison. Court doesn't really seem to care about that under the circumstances, and it's not clear why it would really matter. It's a parody of a pre-existing fictional work, and so whatever, we know what the nature of the work is. It then asks how much is used, and again it says, look, it's a parody, you have to use a lot. And the third factor, the quantity of the work used, is a kind of a sliding scale, and it depends on the nature of the use in question. And again, in the context of parody, using a considerable amount is not a problem. And then finally, the court gets to the fourth factor, which historically had been seen as the most important factor in the fair use analysis, right? To what extent is the allegedly infringing work affecting the market for the original? And the court essentially says, look, we have to weigh the first and fourth factors together. We ask about transformativeness. We also ask about market harm. And we have to look at market harm in a particular way, because there's a lot of different ways in which a work, an allegedly infringing work, could harm the market for a previously existing work, some of which are in fact and should be treated almost presumptively as fair uses. Like, say, for example, you write a critical review of a novel, and in the critical review, you include a considerable amount of excerpts from the novel itself in order to demonstrate your criticisms. Well, that's copying from the novel, right? It could be a substantial amount of copying. And it's pretty clear that a critical review of that kind is going to at least potentially have a negative effect on the market for the novel in question, right? You write a review that says, this novel sucks, you shouldn't buy it. Well, if people take you seriously and believe or take, credit your assessment, they may not go buy the book. That would clearly have a negative effect on the market for the book in question. But copying from a book for the purpose of telling people or showing people why it's bad is precisely the kind of thing that the fair use doctrine was designed to and is intended to protect, right? In fact, it explicitly says criticism is a paradigmatic fair use. So that's not the kind of use that we want to see prohibited, even though it has a negative market effect. right? Well, Acuff-Rose says, look, the problem here is that, we have the exclusive right to make derivative works. And by making a derivative work, they have infringed upon our market to make derivative works of the same kind. In other words, Two Live Crew has created a rap parody of Roy Orbison's song, Oh Pretty Woman. And by doing so, they have limited our ability to exploit the market for rap parodies of Oh Pretty Woman, which is analytically true. They did in fact make a rap parody of Oh Pretty Woman. And, there's arguably a zero-sum game for rap parodies of a song. And therefore Two Live Crew has in fact beaten Acuff-Rose to the punch in this particular context, but the court just rejects that out of hand. It essentially says, look, that's not what we're talking about when we talk about market harm. There's no evidence Acuff-Rose had any intention to create rap parodies of Oh Pretty Woman. And if we credit that argument, then you can make it with respect to any use of elements of a work to create derivative works, right? It's a question-begging argument, as it were, because whatever derivative work you decide to create would fall within the scope of the derivative works, right? Or it wouldn't be infringing at all, in which case the fair use analysis would simply be irrelevant. So the court essentially says, we're not going to credit that kind of argument. And one suspects that, at least weighing on the court's mind when it was engaging in that evaluation was the fact that, of course, Acuff-Rose had refused to license the song in question to Two Live Crew, suggesting that Acuff-Rose had no intention of creating rap parodies of Oh Pretty Woman, or at the very least was blocking Two Live Crew from creating this particular parody, which seems to have encouraged the court to see this as essentially an abuse of copyright ownership, or potentially an abuse of copyright ownership on the part of Acuff-Rose. After all, the purpose of copyright is, at least theoretically, to maximize the production of new works of authorship for the consumption of the public. And Acuff-Rose was, in effect, using its copyright ownership of Oh Pretty Woman to suppress the production of works of authorship of this kind, not to encourage their creation. And if they weren't going to allow them to be created at all, then it can't be infringing on the market for works of that kind for somebody to make it without their permission, because otherwise the work simply wouldn't exist at all. It wouldn't be competing with them. Okay, so it certainly suggests something about how we might think about the nature of the fair use analysis. Particularly, right, the normal way of conceptualizing fair use, especially in the context of transformative fair use, is to say, well, first, a plaintiff shows copyright infringement by proving actual copying and substantial similarity, and then the burden goes to the defendant to assert a defense of fair use and show that their use was transformative and not creating market harm. The question whether that's really what's taking place, right? Or is fair use actually simply part of the infringement analysis in the first place? In other words, is the Two Live Crew song in fact substantially similar to Pretty Woman in the relevant sense at all? Or is a Two Live Crew song in fact not substantially similar and therefore not infringing, even though it borrows many elements? In other words, what do we mean by substantially similar in this context? What do we want to see as the nature of the copying that would lead to a finding of infringement as opposed to the nature of copying that wouldn't? And is it better to look at the fair use analysis as a separate analysis from the infringement analysis, or should we look at them as essentially integrated with each other and different perspectives or different ways of looking at the same question? Anyway, segment from Woman, getting a little bit, and you can also hear that Two Live Crew's parody version similar in some respects, but also quite their song. Okay, so moving forward, in 2020, we saw the basically the resolution, which ultimately ended in a settlement of the Dr. Seuss Enterprises v. Comic Mix case. Dr. Seuss is notoriously litigious, and many years ago brought a more or less identical infringement action against Alan Katz and Penguin Books, who had produced a what they claimed to be, or what they characterized as, a Dr. Seuss parody targeted at O.J. Simpson called The Cat Is Not in the Hat. In that Cat Is Not in the Hat case, Dr. Seuss against Penguin, the court determined that the Dr. Seuss book created by the alleged infringer was in fact infringing because it failed to direct its parody / criticism at Dr. Seuss, but rather used Dr. Seuss as the medium for engaging in parodic expression of O.J. Simpson. And really, in Dr. Seuss v. Comic Mix, the reasoning was essentially the same, right? So what happened here was David Gerald and Ty Templeton went out and decided to do a what they deemed to be a parody version of the Dr. Seuss book, Oh, the Places You'll Go, by mashing it up with Star Wars, right? So, Oh, the Places You'll Boldly Go, they took the Dr. Seuss book and subbed in Star Wars characters with Star Wars themed story, and we're planning to produce this or release this as a kind of parody children's book, which they had funded on Kickstarter. Dr. Seuss Enterprises brought an infringement action and ultimately ended up getting an injunction against the publication of the book in question. The district court found that it was in fact a fair use, but the Ninth Circuit reversed on essentially the same grounds that the court ruled on in the previous Dr. Seuss parody case, saying it's not really transformative, essentially because you took a whole bunch of elements from Dr. Seuss without actually directing any critical, any critical discussion at Dr. Seuss itself, right? And in fact, you use Dr. Seuss as the platform for creating this new work of authorship, which was not a criticism of Dr. Seuss, but rather a mashup of Dr. Seuss with Star Trek, reflecting on the humorous capacity or the humorous consequences of combining the two. The court also, kind of walked again through the factors, saying, oh, well, Dr. Seuss is a fictional work, not a non-fictional work, therefore, weighs in favor of Dr. Seuss. And you use a lot because, the entire book is modeled on the entire previous book. Again, not sure, if you do think it's a parody, then it's not clear why that would matter, given that, that's the whole point of the parody, is to make it match up against the Dr. Seuss book. And then finally, they suggest that there is market harm in the relevant sense to Dr. Seuss, insofar as they're both children's books targeted at an audience, presumably. They're both characterized, at least, as children's books, and therefore both targeted at an audience of children. You might ask yourself to what extent you agree with the court's conclusions here. Was it driven primarily by the fact that it had ruled in a prior case with a similar factual scenario and come out this way, and it didn't want to upset its previous ruling on the basis of more or less identical facts? Or was the court really asking the right questions when it comes to the fair use analysis? In other words, what was it really reacting to, and was it reacting correctly under the circumstances, right? How do we and how should we think about this kind of use? Is it transformative in the sense of creating new meaning? Is that what we mean by transformative? Like, what does it mean to create new meaning, as it were? Does it change the nature of the original work in any substantial way, or in any way that we ought to be concerned about suppressing through copyright law? And what about competition, right? I mean, is the Oh, the Places You'll Boldly Go book likely to actually compete with Dr. Seuss in any meaningful way? Or would they be essentially targeting different audiences, or targeting different audiences in different ways? Leave it up to you, and we'll talk about that in class.